nine, number 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 nine.
All righty.
We have launched.
Yes, we have. Sorry for the long intro, but I did want to make the point of...
it could have been longer. That's
number 9.
Long song.
Because we're calling the Tonight Show Planet Green Trees episode number 202. We're calling it Footnote number 9. Maybe you noticed the song that I tried to play earlier, but ended up with birthday. And so it goes. But today, of course, is June 5th. Is it June 5th? 2014, and it is Thursday, and for the next 2 hours we're going to be talking about medical cannabis on this blog talk radio show called Planet Green Trees. I'm your host, Michael Comorn. The call number is 1-347-326-9626. You can listen to us at planetgreentrees.com. Alongside me in the studio, which is very quiet tonight, one only Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Not here, but locked in via phone as our other participants in our regular studio audience, Rick Thompson from the Compassion Chronicles, and Rick, of course, is I believe on the line and will be bringing the news to us a little bit later. Also, other contributor and producer, week in and week out, providing the most up-to-date and relevant guests and content for our weekly blog talk broadcast, Jamie Lowe from the Third Coast Compassion Center. And, of course, he is responsible for all the guests we get week after week. If you don't like him, don't like what's going on, call him. Don't call me. But the guests we have lined up for tonight are, and the topics we're going to be talking about are as follows. Tonight, the Victory in Oak Park. Safer Mich Coalition holds a fundraiser night at Dominick's on Monroe St in Ann Arbor, starting at 7:30. And also on the headlines, cities and townships around the state are still creating and enforcing restrictive ordinances on medical marijuana activity, even in light of the Michigan State Supreme Court ruling in Ter Beek versus Wyoming. And here is the catch of the name and title of the show. Relying upon the Ter Beek versus Wyoming footnote number 9. And also we're going to be discussing and talking with maybe the National Cannabis Industry Association. I don't even know what that is, but we're going to hear about that. And, of course, Rick and Jamie are attending and acting as roving reporters at the fundraiser for Safer Mich tonight. And that event is, as I indicated, at Monroe St in Ann Arbor, starting at 7:30. I see that those guys are in the queue. I'm going to get them on the air in a second. Let's do that right now. Hold on. I believe we've got the one and only Rick Thompson from the Compassion Chronicles and your world-famous producer for Planet Green Trees, Jamie Lowell. Gentlemen, welcome.
Right. Hello, everybody.
Glad you could be
Hey,
here.
Rick.
Glad you could be here. I know you're going to bring us... Well, Rick, of course, is at the... you're not at the event. Jamie is. He hasn't piped in yet. You are in Flint.
Yeah,
we are going to be relying upon you to bring us the news and participate in some of these conversations because it is an interesting discussion. Essentially what we're going to be talking about is how this ordinance... I'm sorry. Let me start over. How the cities still, despite the Supreme Court of Michigan ruling in Ter Beek versus Wyoming, affirming the Court of Appeals decision that state law trumps city law and the federal law trumps state law. And certainly under that guise, that legal framework, cities cannot abrogate the protections of state law. There are limitations, there are some regulations that could potentially be utilized, but the footnote that I speak of number 9, is specifically from Ter Beek versus Wyoming. Contrary to the city's concerns, this outcome, the outcome of Ter Beek, does not create a situation in the state of Michigan where a person, caregiver, or a group of caregivers would be able to operate with no local regulations of their cultivation and distribution of marijuana. Now, because we are the premier blog talk radio show, we actually had Dan Koropkin from the ACLU on the day of or the night of the decision, and he chimed in on what his thoughts were. And his thoughts were that it would appear, just as I outlined it, and I'm relying upon his interpretation and the interpretation in its plain wording of the ruling where the court said that the cities cannot abrogate the protections of state law. This footnote is really intended to, I think, allow for regulating for safety purposes certain zoning restrictions, maybe signage, hours of operation, typical things that cities are entitled to, for limited purposes, regulate, but certainly not to abrogate the protections of state law. And I want to talk about this. We're going to talk about this, and this is really the topic, and we're also going to be getting some opinions from the individuals who are participating at this Safer Mich party or fundraiser at Dominick's. And also calling in tonight is going to be the head of the Northern Lights Provisioning Center, John Wells, who's going to discuss a policy in Greenwood Township, as well as medical marijuana reform activist Victor Vicious Hansen, who's an activist, major supporter, and contributor to the Human Solutions, also a former radio show host. He's going to discuss the situation, which is, I understand, totally bizarre in Delray Township and their prohibitive policies. All right, so I'm going to rant in a little while, and we're going to have news, as I said, from Rick. And I do want to give a shout-out to a couple people. The first, of course, Dewey and Pam, who are not in town this week. And I'm jealous, of course, you're on vacation and not thinking about any of the crazy stuff that goes on. But hope you guys are having fun, and we're going to need you next week, so make sure you're back in play promptly, if you don't mind. Also, the Michigan Medical Marijuana Association, michiganmedicalmarijuana.org. I want to thank the administrators and other volunteers and who help participate in helping the forums be a safe, comfortable environment for people to talk about medical cannabis and evolve the conversation. Dr. Kumar Singh of the Green Light Clinic, telephone number. We'll announce it in a second, but I do want to indicate that, again, the bona fide doctor-patient relationship has never been more important. There are very few facilities. We've mentioned them on the show a number of times, but Dr. Kumar Singh is one of them that, in fact, is fulfilling the obligations outlined in the law. There are many others that are not. And those that are fulfilling it, such as Dr. Kumar Singh, Dr. Townsend, Dr. Crocker, Dr. Paul Myers, there's many, not as many as there needs to be. They should not be discouraged by the unlawful competitive market by which advertises that there is no need for, or the law does not allow for, or require follow-up. This is just simply not true. So, because I'm going to rant a little bit, I want to, I know we're tight on time, but also maybe short on content. So we're going to be playing a lot of music tonight. And Rick's going to be talking a lot and a lot of conversation. So is Jamie. Jamie, are you there?
I'm here.
Okay. All right, good. So far, so good. I'm going to put you guys on hold for a second and do my rant, take a break, and come back. And Rick, we're going to do the news. And Jamie, you can give us the updates in terms of where, who wants to come on the show and talk. And I know we're waiting on our call-ins, as I said, from John Wells, activist for a long time and a friend of the community, and Victor Vicious Hansen from Delhi, who's got some weird stuff going on. I want to rant for a second about a topic. I referenced it last week. I was in a trial this past week, and it's very unusual. But it also, like the medical marijuana and marijuana reform, legally is evolving as a new and interesting field of law. And some things happened this past week which were so bizarre and weird that I just feel like sharing it. And also, despite the outcome and the result, I think it's important to discuss and identify, as was done with medical cannabis and cannabis reform at a point in time when very few people were aware of it, but now finds itself nationally in favor of or supportive of at least 70% for medical marijuana, at least 50% for marijuana legalization in general. But I'm talking about something which is a much more sensitive topic, and it deals with the point in time where the government, the police, and the establishment of the enforcers of laws are entitled to exceed or come up to the line of their authority. And at what point in time does a citizen have a right to lawfully resist? I was involved with a trial this past week which started out as a medical marijuana case involving a search warrant. And it's not that often that you get rulings like I got in this case, and I don't know that many lawyers can say that they've had these kind of bizarre situations, or even two legal rulings in your favor in one case. It doesn't result in a outright dismissal. But the first one was Cumorah law got involved in this case in Shiawassee, and there was an execution of a search warrant at my client's house at 11 p.m. on a July night, and swarmed the house and entered the house, opened the door to come in without any visibility of knowing, any visibility, I said, of seeing. The lighting at the time was such that my client was in a lit family room looking out into the darkness of his front lawn, and saw cars barge up into his up to the house where the lights were blaring into that room. Saw figures run into the door, and then all of a sudden the door opened, and he went and tried to shut the door thinking he was being robbed. And eventually he hears police warrant, search warrant, police search warrant, opens the door. They grab him by the arm, throw him to the ground, start screaming, give us your arm, stop resisting. Of course, he's laying on his arm, can't get his arm out because the police officer's knee is in his back, at which time the so-called marked police officer, who was in a brown jersey without a badge and pitch black, was not visible to anybody, decided it was time to deploy his taser. It did not stick, tried to put it back in the holster, and it went and almost hit the other police officer. And after getting them into handcuffs, searched the house and found approximately 9, they called plants, 2 of which were mother plants, and the others were barely rooted clones. The search warrant was based, of course, upon a tip from an unnamed individual who indicated that my client was a legal caregiver and was now expanding his grow to a new, over the amount of plants he was allowed to have, out of the house and into the garage, which was also on the property. So the tip, unnamed information, unnamed source, unnamed tipster, gives information that there's no personal knowledge.
Unnamed liar.
And he says that my client is a medical marijuana caregiver who is expanding his grow to the garage. The law says that in order to establish probable cause, the officer has to go corroborate the information. The officer goes to the house. He, in turn, looks at the house and sees that the window is blocked out with a plastic sheet, which to him is indicative of marijuana growing. But what information is he actually supposed to corroborate? He's supposed to corroborate that marijuana growing, which he knows there's marijuana growing, is more than he's legally allowed to have. So corroborating the front window doesn't seem to be like much corroboration at all. In fact, it would be expected. The officer leaves with this only one observation, doesn't comment at all about the garage, which is the targeted area and the subject area that the expansion was supposed to be in, and then goes and requests of the Drug Enforcement Agency of the federal government, this is a state case, state investigation, magnet officers in Shiawassee County, and knowing full well as trained narcotics officers, they cannot legally acquire in any way, shape, or form the electrical records of my client by way of subpoena. They would need to go to and get a subpoena signed by a judge, because the state law of subpoenas that very few people really understand or realize is that it can only be signed by a lawyer, a judge, or a clerk of the court. Notice, lawyer, judge, or clerk of the court. Not included in that list are police officers. So they cannot prepare a subpoena. They do this all the time, illegally request what I would describe as private information from banks, cable companies, electric companies, and get this information and try to corroborate it as being indicative of marijuana growing. But they didn't do this in the case because they know under state law they can't. So instead they circumvented state law, called their buddy in the DEA, and the DEA is allowed to issue subpoenas. And they issued a subpoena and got electrical records back, which indicated that, in fact, from January to the time of the raid in July, the electrical usage had gone down. That in the month of June and July, it had gone down. So the corroborating information that was sought of an increase in marijuana plant growing was actually counter to what was needed in order to corroborate and justify probable cause. With no other, and the final comment was based upon the training and experience of this particular affiant or drug enforcement officer of Magnet, that he believed that this electrical usage was way above the average home and therefore corroborated the information. Now, without stating what an average home is, or without stating that this was not an average home because there was 2 other buildings on site, including the home, which would be the third, which had electrical going to it. And, of course, because of the electrical going to it, there was a probability that there was going to be a much greater amount of electrical use than an average home. So with all this being said, they go and get a search warrant and execute it. As I indicated, this fight ensues, not a fight, a attack of my client who doesn't know that it is actually the police. And so we challenge the search warrant, file a motion, take some testimony, and the judge rules that, in fact, the search warrant is invalid and says it is an invalid search warrant and quashes the affidavit and search warrant, but determines that the police have acted in good faith, which is one of the exceptions to the exclusionary rule. But I would argue and tell you now that this is inaccurate because there's not a case that supports the premise that good faith could ever be seen if the affiant is the individual who also executed the search warrant, because it's the affiant that brought this bad, crappy, terrible, non-probable cause affidavit to the search warrant and coerced, convinced, or provided, and also the magistrate made an error and then gave it back to the affiant, and not with good faith, never with good faith, or could it ever be said with good faith when executed the search warrant. But nevertheless, the judge ruled that it was an invalid search warrant, but the evidence, the marijuana, was going to stay. So we filed this section motion. And in fact, the judge dismissed the charges, even in light of Harwick, even in light of Tuttle's. Flat out, doctor testified, patients testified, client testified, no question of fact. Could any person find and dismiss the charges pursuant to Section 8? We also submitted our proposed order to retrieve back all the property, because many forget at times that a Section 8 victory is a return of property. Nevertheless, so the case, which started as a marijuana case, results in a illegal search warrant, but the marijuana stays, and then the marijuana gets thrown out because of Section 8. But oddly, find ourselves in a resisting and obstructing because 3 counts came out of that interaction at the door. The first one being when the police claimed that my client knew it was them, shut the door on them. That's resisting 1. When they get inside, they say he's resisting them trying to put the cuffs on him, which of course is him laying on his arm and trying to pull it out, and them calling that from the 2 victims, cops, police officers, that they were, obstructed or something. Anyways, so we picked a jury this last week, and what never happens, and you hear very few attorneys say this, is that we pick a jury on Tuesday and Thursday. The Michigan Court of Appeals issues an opinion that's right on point in this issue. It was a follow-up opinion, the first published opinion since the Michigan Supreme Court had spoken about this issue, which I want to raise, which is that despite the long-standing statutory rule that an individual in Michigan could never argue that they were legally justified in resisting a police officer's arrest, and this has been the statute in Michigan under 750.81D forever, and it's a statutorily crafted law that says and lays out the exact elements of resisting and obstructing, and nowhere in it does it allow for an individual to ever be justified in resisting an individual police officer. The only defenses possible would be like they didn't know it was a police officer, or they didn't resist, obstruct, hinder, assault, etc. But the case of People v. Moreno asked the question, and the Supreme Court answered it, whether or not the statutory scheme was intended to abrogate the common law rule, which was if you're in a constitutionally protected area, you can fight with whoever you want if they are committing illegal activities. Or said another way, the police have to be acting lawfully in order to claim that you're resisting. Or if the police are acting unlawfully and you resist, they cannot make out a case that you resisted. So, we began the case on a week ago Tuesday. We picked a jury. The court was aware of this Moreno case. I filed a motion to quash the bind-over, saying that no way the law had been, that the elements had been established at the preliminary exam that the police were acting lawfully in light of the court's ruling that search warrant was invalid. So when the police are there executing an invalid search warrant, what legal right could they have to be on the property or claim that my client resisted anything when he's in his home, which is his castle, and he's allowed to run into his home, he's allowed to lock the doors, he's allowed to keep whoever he wants out, especially someone that's not there lawfully. So the judge denies my motion to quash. I think it's bad policy if people can resist the police. It's a reversible issue, I think, on appeal. And we pick our jury, and the judge doesn't give the full instruction that I'm asking for, which is this third element, which requires the police to be acting lawfully at the time that they are. And then, on Thursday, as I said, the Michigan Court of Appeals issued an opinion saying that Moreno applies retroactively, number one. Number two, that even though it's blatantly clear in Moreno that it had created this third element of requiring the police to be lawfully at the place that they are, in order for them to claim that an individual resisted, we, in this case, People versus Quinn, are going to state unequivocally that this is the third element, even though it's obvious, but we'll state it here. It's published opinion. So we go back to court on Tuesday, and I say, Judge, blah, 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 this happened, and he reads the third instruction. But what's interesting about the case is, first of all, anytime you're defending or resisting, obstructing, the claimed victims are the police officers. Understand that this is probably the most difficult type of case that a defense attorney can handle, because I think, despite the fact that many of whom may be listening tonight and are aware of what you could call a police state, I, as a lawyer, will tell you that to all that are involved in this, it's not a question of whether or not the police are going to lie. And I don't mean that negatively, but it's part of the game. It's aware. People are aware of it. Judges know it. Lawyers know it. Prosecutors know it. It's a question whether you're going to catch them in the lie. So this is well known to me. But the idea that the police are able to get away with it is always the challenge of a lawyer. The drug cases are always about the police officer's integrity. But that's them as witnesses. It's different when they are victims. And there still remains many, many people who are fearful and concerned more so of what else goes on beyond the police. And they need somebody, and they need to rely upon the police as people that are protecting them and being safe for them. And the police are trained witnesses. They practice testifying, and they work together, and they understand in a lot of ways how the protocol of how the police operate. And I think that they have a general trustworthiness to most people, or at least our culture wants to trust them. And it's a difficult concept to be able to explain how important it is that people at least realize these rights, that this is a new emerging freedom in Michigan that did not really exist before, that it not only happened by declaration of the Michigan Supreme Court, but reaffirmed in this recent Michigan Court of Appeals opinion, which says that the police clearly have to have a legal right before they can claim that you are resisting their anything. And I think it's important in light of just our basic constitutional principles, also in light of the fact that we grant a tremendous amount of authority to our law enforcement, and that law enforcement authority needs to be checked. The place that it's going to be checked is with the jury system, because the police aren't going to say that they did anything wrong. They're usually not going to admit that they made mistakes, and they're usually going to put on their case that makes the point that they didn't make mistakes. So if there's any appeal I can have to anybody from my past experience, it's like, please tell your friends, neighbors, loved ones that Michigan allows for persons in protected constitutional areas to resist the police if they're acting unlawfully, and that should be their right, because we as a culture, as a country, as a nation, it was born out of resistance. We got sick and tired of the king telling us what we could do in our home, what we could say in our home, who we could pray to, where we could congregate, when we could fornicate with our wives, what we could say to our children, and certainly of the government coming into our homes and doing whatever they wanted to. That's why we have the Fourth Amendment. It is the most sacred of our rights. It is a place where one can retreat to get away and have privacy. And the authority of the police ends at the front porch. In absence of some legal basis, they should not be able to go in, and their entry in under any other circumstances other than the legal one, they should be perceived as people that are breaking and entering. It's common law. It's what the country was founded on. That's my rant. So with that being said, let's take a quick break, and we're going to be back. I know, come right back with Rick in the news. Jamie, I know you're yelling. Went over a little bit. Oh, there it is right there. Okay. And we are going to be right back.